provide me with any law that rebutted that. I didn't receive any, so I'm working under the assumption that you doesn't have anything to rebut that theory, that statement of law. I'll let you make any arguments that you want at this time anyway.
They haven't proven a robbery. They haven't proven
I think that's a question for the jury. I just get into the law. The jury gets into the facts anyway. As there's testimony of what property was traditionally in the possession of the defendant, Mr. Carpenter, and what was no longer there anyway. And I think that that's a jury question whether there was a robbery or not anyway. So, all right. I'm going to give S3, which says, the court instructs the jury that the state is not required to prove the defendant had the intent to rob Kirby Carpenter prior to the killing to support a conviction of capital murder with the underlying felony of robbery. It is sufficient for conviction if the state proves that the crimes murder and robbery were connected in a continuous chain of events. Intent to commit the robbery may be inferred by all the circumstances surrounding and connected with the killing of Kirby Carpenter. I'm going to give at S3. We also left here Friday with the question of whether the defense was entitled to an alibi instruction. I think
hey to everybody that's in the building. So I'm trying to stream 2 trials at one time, and I'm trying to go live at the same time, y'all, because I have some stuff I want to go over when Lek went live last night, but I'm trying to figure it out. So this is one stream. I'm gonna see if I can pull off the other 2, y'all, so bear with me, but it might only let me do this one. We'll see.
at that time there was a D1, D2, and D5 that all dealt with alibi instruction. The court's opinion that is the defense theory of the case, and the defense is always entitled to an instruction on its theory of the case if there's any evidence, even more, regardless how scant, that supports the instruction. So I'm going to give an alibi instruction. We're down to which one of these instructions that I'm going to give. We had some emails yesterday, and the state was objecting to the first paragraph of D5, and I've taken the liberty of, and I agreed with that, and took the liberty of deleting the first paragraph of D5. So we're down to D1, D2, and an amended D5. The defense has indicated they want alibi instruction, and they are entitled to a alibi instruction. We're just arguing over which one it's going to be now. Mr. Hill, I'll give you an opportunity to express which of the three you think is the appropriate instruction. I'll give the defense state an opportunity to express which they feel is an appropriate instruction, and then I'll make a decision. If y'all would tell the jury we're out here working, we're not just drinking coffee and eating donuts, even though I have been eating donuts. Good morning, young lady. Good morning.
I'm going to maintain my position for the record that D5, as we submitted it last week, is appropriate. It's an accurate statement of the law, and that's the one that we prefer.
Let me, Lynn, did you have that original D5 that
I have it right.
she got me a copy coming here?
Sorry.
I think the first paragraph of D5 has been more than adequately covered, and at least 2 prior instructions. So I don't think the first paragraph is necessary, and I'm going to refuse D5, the
Is this the
original.
one that you're giving instead?
Do what?
Is this the one you're giving?
That's the one
instead?
I'm proposing without the first paragraph. And so you have your position on D1, D2, or that amended D5 that you've got there without the first paragraph.
Well, I prefer my original that I submitted last week. But
I understand
I
that.
will accept the one that I have in my right hand.
Okay. You're gonna get one,
Yes, sir.
either D1 on alibi, D2 on alibi, or D5 on
I
alibi.
prefer your amended version.
On D5,
Yes, sir.
all right. State had any objection to giving D5 in lieu of D1 and D2?
No, sir.
All right, I'm gonna give D5 then as amended. I thought that was the most succinct statement of the law. All right. So I'm gonna go over the instructions that the court is proposing to give. And if you've got any objection, and I'm gonna give them in the order that I'm fitting to call them out anyway. Court's gonna give court's instruction 1, court's instruction 2, court's instruction 3, court's instruction 4, court's instruction 5, court's instruction 7, defendant D4, D5, S3, S2, and I'm going to conclude, last instruction will be S1, the elements and the form of the verdict. Other than any objection instructions that I'm going to give.
Nothing more than what I've
All right. Is everybody ready to bring the jury in?
Yes, sir.
And I believe he said we're going to have an hour for, each side have an hour for closing statements. Do you want me to give you a warning on 30 minutes, or you just want to talk till you're tired?
I'd rather just keep going.
Do what?
I don't think I'm gonna take 30, but,
I'll give you a 2-minute warning on 30. How about that? Mr. Hill, would you like a warning on your hour?
Maybe 5 minutes, but I'm not going to take it.
Okay. Give me just 1 minute to gather some stuff. I'll be right back. Y'all be getting your jury ready to come on in, okay? When the jury gets out, I'll spend about 10 minutes reading the jury instructions. The state will then have, I'm sorry. Go ahead. You need me to?
I interrupted her. You can keep going.
Okay. Be prepared to sit for about 40 minutes. We'll have a little, if you need a little break then, you want to leave at that time, you can, then be prepared to sit for about another 45 minutes to an hour. I don't want anybody coming and going when the attorneys are making their closing arguments. So, and then you'll have about another. So don't get up and leave during the closing arguments. And Mr. Bailiff, once they start their closing arguments, don't let everybody come in until they have a break, okay? I don't want to be any eruptions, all right?
Your Honor, I'm missing an exhibit.
I didn't get it. I promise.
36.
36. 36 is, it's been omitted. Safety box, easement and log, Saltville branch. You find it? I knew it was going to be there. Miss Kathy's in charge. You was in charge. I know you had your stuff together. Let's. I want to talk. Y'all come up here and approach Thad or Ben or somebody. Anyway. I'm not rushing anybody, but are you ready? Which is sort of like rushing you. Let me do this. Let me give you an opportunity between the state's closing and your closing, okay? Jerry's been waiting long enough. And I will, I'll have these instructions available if you want to use them in your closing, okay? All right, show the jury in if you're ready. I believe you got to stand, Mickey, so everybody can see you. If you would, okay. right. Look like everybody survived the weekend. Good morning, all. Had some good football games. Some turned out the way I wanted. Some turned out the way I didn't want anyway. I trust no one had any problems with the court's instructions not to investigate the case, not to discuss the case, not to perform or express any opinions about the case. If you've had any problems in that regard, let me know. If not, if you don't let me know, I'm assuming you have. All right. At this time, what I'm going to do is I'm going to read you the instructions of law, what the law is. As I told you, if we started this thing, I get to decide what the law is. Y'all decide what the facts are. After I've read the law to you, the state will make its opening, closing arguments. And then the defense will make its closing argument. And because the state bears the burden of proof, they'll get the last bite at the apple and have the last closing argument. So pay attention as I read these rules to you. Members of the jury, you have heard the testimony, received the evidence introduced in the course of this trial. The court will presently instruct you as to the rules of law which you will use and apply to this evidence in reaching your verdict. When you took your place in the jury box, you made an oath that you would follow and apply these rules of law to the evidence in reaching your verdict in this case. It is therefore your duty as yours to follow the law which I shall now state to you. On the other hand, it is your exclusive province to determine the facts in this case and to consider and weigh the evidence for that purpose. The authority thus vested in you is not an arbitrary power, but must be exercised with sincere judgment, sound discretion, in accordance with the rules of law stated to you by the court. Both the state of Mississippi and the defendant have the right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case, and that you will reach a just verdict regardless of what the consequences of such verdict may be. It is your duty to determine the facts and determine them from the evidence produced in open court. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. You are the sole judges of the facts in this case. Your exclusive province is to determine what weight and what credibility will be assigned to testimony and support and evidence of each witness. You are required and expected to use your good common sense and sound, honest judgment in considering and weighing the testimony of each witness who has testified. Although you are the sole judge of the facts, you are duty bound to apply the law as stated in these instructions to these facts if you find them from evidence before you. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of an opinion you may have of what the law ought to be, it would be a violation of your sworn duty to base your verdict on any other view of the law than that given. Arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but are not evidence. Any arguments, statements, and remarks having no basis of evidence should be disregarded by you. The evidence which you are to consider consists of the testimony of the evidence, witnesses, and the exhibits offered and received. Production of these evidence in court is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourself with the reason for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any ruling by the court on these motions or objections to the evidence that the court has an opinion on the merits favoring one side or another. You should not speculate as to possible answers to questions which the court did not require to be answered. Further, you should not draw any inferences from the contents of those questions. You are to disregard all evidence that is excluded by the court from consideration during the course of the trial. You are not bound by any rules of parliamentary procedure in your organization or in your deliberation. But the court suggests that you choose a person to speak for you. You may vote on your individual beliefs either by show of hands, secret ballots, or any other method you choose. If in stating the law to you, I repeat any rule, direction, or idea, or if I state the same rule in a different way, no emphasis is intended, and you must not draw any emphasis therefrom. The form of your verdict is suggested in another written instruction or instruction. Your verdict may be in one of the suggested forms. It should be written in handwriting or printing or one of the individual drawers on a separate sheet of paper furnished to you for that purpose. None of the individual drawers has to sign your verdict. The order in which these instructions are given to you and the manner in which these instructions and exhibits are numbered has absolutely no significance. You will have with you in the jury room all the papers and evidence applicable to this case. Although during the trial other papers, documents, exhibits, or charts may have been mentioned to you, once you have entered the jury room for deliberations, no other documents, papers, exhibits, or charts may be given to you. Transcripts of the trial testimony or parts of the trial testimony are not available. When you enter the jury room for deliberation, the court suggests to you that you discuss the facts of the case and review these written instructions before you begin voting or attempting to decide the case. The burden of proving the defendant guilty of every material element of the crime with the defendant is charged is upon the state of Mississippi. The law makes no distinction between direct and circumstantial evidence, but requires that before you can return a verdict of guilty, the state of Mississippi must prove beyond a reasonable doubt that the defendant is guilty from all the evidence in the case. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty beyond a reasonable doubt. The presumption of innocence attends the defendant throughout the trial and prevails at its close unless overcome by evidence which satisfied the jury of his guilt beyond a reasonable doubt. The defendant is not required to prove his innocence or to offer any evidence at all. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree thereto. In other words, all 12 of you must agree on a verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching agreement if you can do so without violence to your individual judgments. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion. If convinced that your previous opinion was erroneous, but do not surrender your honest convictions as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Upon retiring to the jury room, you will select one from among your number to act as a foreperson. The foreperson will preside over your deliberations and will be your spokesperson before the court. If it becomes necessary during your deliberations to communicate with the court, you may send a note by the bailiff. During deliberation, no member of the jury should ever attempt to communicate with the court by any means other than in writing, and the court will never communicate with any member of the jury on any subject touching the merits of the case, otherwise in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even me, how the jury stands, numerically or otherwise, until you have reached a verdict, unless asked by me in open court. Notes are only a memory aid, and the jury's notes may be used only as an aid to refresh that particular juror's memory and assist that jury in recalling the actual testimony. Each of you must rely on your own independent recollections of the proceeding. Whether you take notes or not, each of you must form and express your own opinion as to the facts of the case, and the individual jurors may be used by that juror only and may not be shown to or shared with other jurors. Jeffrey Dean Spence has entered a plea of not guilty. This means that you must presume or believe Jeffrey Dean Spence is innocent. This presumption of innocence stays with Jeffrey Dean Spence throughout each stage of trial unless the presumption has been overcome by evidence that satisfied the jury of Jeffrey Dean Spence's guilt beyond a reasonable doubt. Jeffrey Dean Spence is not required to prove his innocence. Jeffrey Dean Spence is not required to present evidence or prove anything. Because Jeffrey Dean Spence is claiming an alibi for his defense, that is, he was elsewhere on the date and time of Kirby Carpenter's death, the state has the burden of proving beyond a reasonable doubt that Jeffrey Dean Spence was not elsewhere at the time of Kirby Carpenter's death. The court instructs the jury that the state is not required to prove the defendant had the intent to rob Kirby Carpenter prior to the killing to support a conviction for capital murder with the underlying felony of robbery. It is sufficient for conviction if the state proves that the crimes murder and robbery were connected in a continuous chain of events, intent to commit the robbery may be inferred by all the circumstances surrounding and connected to the killing of Kirby Carpenter. Robbery, as referenced in these instructions, means that the state proved the defendant unlawfully, willfully, and feloniously did take from Kirby Carpenter or from his presence his personal property with the intent to permanently deprive Kirby Carpenter of the property, and this was done against Kirby Carpenter's will by violence to his person or putting him in fear of immediate injury to his person by the exhibition of a deadly weapon. The defendant, Jeffrey Dean Spence, has been charged with a felony crime of capital murder. If you find beyond a reasonable doubt from the evidence in this case that Jeffrey Dean Spence, on or about the 30th day of November 2022, in Tippah County, Mississippi, y'all approach. It's been over the weekend, I forget. All right, I'm going to start the instruction over. The defendant, Jeffrey Dean Spence, has been charged with felony crime of capital murder if you find beyond a reasonable doubt from the evidence in this case that Jeffrey Dean Spence, on the 30th day of November 2022, in Tippah County, Mississippi, unlawfully, willfully, and feloniously killed and murdered Kirby Carpenter, a human being, with or without deliberate design to effect the death of Kirby Carpenter, while engaged in the commission of robbery, without authority of law and not in necessary self-defense, then you shall find the defendant guilty of capital murder, in which you should write your verdict on a separate piece of paper provided by the court for that purpose in the following form. We, the jury, find the defendant Jeffrey Dean Spence guilty of capital murder. If the state has failed to prove any one or more of these elements beyond a reasonable doubt, then you shall find the defendant not guilty of capital murder under the indictment, in which case you should write your verdict on a separate sheet of paper provided by the court for that purpose in the following form. We, the jury, find the defendant Jeffrey Dean Spence not guilty of capital murder. All right. Those are the instructions of law that are to govern the case. These will go back with you, and these written instructions will go back with you into the jury room. Y'all can consult those when you begin your deliberation. Is the state ready to make its opening and closing arguments?
Yes, sir.
All right.
Thank you.
Y'all guard the door now. Don't let anybody come and go during this portion of it.
Thank you. Yeah, that's fine. May I proceed? Sure. Thank you. Good morning. The judge has instructed you on the law. As I said in my opening statement, you're the trier of facts. You judge the credibility of all the witnesses that you heard last week. Now, when you go back and retire and go back in the jury room and deliberate, you'll apply the evidence to the law and make your decision. And as the judge has said, you can take the instructions, should take the instructions back into the jury room with you. Now, Mr. Spence is charged with capital murder. We have to prove all the elements of capital murder beyond a reasonable doubt. The first element is that on or about November 30th of 2022 in Tippah County, Mississippi, while Jeff Spence was engaged in the commission of robbery, Jeff Spence unlawfully, with or without deliberate design, killed Kirby Carpenter, a human being. Those are the elements. November 30th of 2022. Kirby's last words to Caitlin were at 6:37 p.m. He was traveling as Geno's, which is a tire store in Boonville. Kirby is never heard from, and you will see that there are no outgoing texts or calls from Kirby's phone. Scott Watson, who was the deputy coroner that day, and Dr. Erin Robinson, who didn't testify, but her report and the death certificate were admitted into evidence, declared that the date of death was November 30th of 2022. We can see this from the death certificate, which is right here, admitted into evidence. And highlighted there is 11/30/2022 in the right-hand corner is the date of death. Tippah County, Mississippi. His body, no question, was found at 6071 County Road 600 in Tippah County. That's Kirby Carpenter's home. Now, let's talk about robbery. Robbery is just what you would think it would be. It's taking someone else's property by violence using a gun in this case. A person is in the commission of robbery even if the robbery occurs after the killing. And the judge read you an instruction that tells you that as long as the state has proved that this is a continuing chain of events, the murder and the robbery, we don't have to prove which one occurred first. So even if Jeff robbed Kirby after killing him, he is still in the commission of a robbery. Now, let's talk about the property. You heard testimony early on in the trial from Bart Adams. Bart Adams is an attorney in Ripley, Mississippi. He knew Kirby for about 12 to 15 years, knew him, did some legal work for him, and he knew him as an acquaintance. He did business with him. He traded gold, silver, and collectible coins with Kirby. He also testified that in his dealings with him, Kirby always carried a satchel. I think Bart called it a man purse. And in that, I'm going to call it satchel. In that satchel was cash and business documents. Now, he also always carried a pistol with him. The gun and the satchel were never recovered. They weren't on Kirby's person, they weren't in Kirby's house, and they weren't in Kirby's truck that was locked in the driveway with the groceries he had purchased at the Kroger in Corinth on 11/30/2022. 22 Magnum shells were found on Kirby's person at the crime scene when the body was discovered on December 2nd of 22, but no gun. Where'd the gun go? Something he always carried. Now, let's talk about the personal property, including the business documents. Where were they found? You got to look to the Chilhowie, Virginia branch of the Bank of America. These pictures have been entered into evidence, and the actual evidence you can take back to the jury room and examine. Now you'll see some, what Mr. Hill calls the commercially packaged items that you can buy on Royal Street in New Orleans, but you also see a lot of loose coins. These are all items that were part of Kirby's business. North Mississippi gold, silver, and coin exchange. Also contained in the Chilhowie branch were miscellaneous papers. I'll have more to say about that in a little bit. Jeff killed Kirby with or without deliberate design. Now, what is deliberate design? Deliberate design means we don't have to prove that Jeff Spence intended on killing him. He killed him, but we don't have to prove it. Jeff Spence shot Kirby in the right shoulder and the chest with a shotgun. Kirby's death is caused by a shotgun blast. Where do we get that information? from the death certificate and the pictures to Kirby Carpenter's neck and chest area, right shoulder. The doctor, the medical examiner, ruled this a homicide, and the cause of death, which is in the right paragraph, gunshot wound, gunshot to right shoulder and chest area. Now, there's a lot of evidence in this case. We're going to take it one at a time because once you put all the pieces together, everything points to Jeff Spence. The timeline. In my opening argument, I suggested to you that the timeline is critical in this case. Kirby's timeline, Caitlin's timeline, and Jeff Spence's timeline. Again, Kirby's last words to Caitlin, to anyone, was at 6:37 p.m. in the form of a text message when he's passing Geno's. Again, here's the text message. You can see it 6:37 p.m. on November 30th of 2022. Where are you? Geno's. Now, if you recall, Caitlin's testimony was that on the night of, actually on the 29th, Jeff Spence suggested to her that she go out with Bailey Rich, her friend, on the night of 11/30/2022. That didn't work out because Bailey had her baby, her husband was home, whatever. They did not get together. But Jeff suggested they get together. Yeah, that's just why. Because he did what he had to do. We know where Caitlin was. We know Caitlin was at Walmart in Boonville. And we know she went to the parking lot. How do we know that? Because we've got video evidence that's been entered into the evidence showing her at the Walmart parking lot, and she stays there until 7:52 p.m. Her testimony was that after she left, after breastfeeding, she went to pick up Chinese food and headed home. 15 to 20 minutes to Kirby's house, where she lived. So that puts her, even if she's speedy picking up her Chinese food, that puts her home about 8:15 p.m. Kirby was murdered approximately 7 p.m. Now, Jeff and Karen left Mississippi after being in Mississippi on 11/29/22, one day before the murder. "19 hours. I want you to remember that number. You heard the officers. Caitlin said it was 10. Say it was 10. You got an hour time difference. So when you're traveling to Virginia, you pick up an hour. When you're coming back to Mississippi, you lose an hour. 19 hours. So if the Spences left Mississippi 1 to 2 p.m., giving them a 10-hour drive, adding an hour for the time change, that puts them home in Saltville, Virginia about midnight on 11/29/22. Kirby's killed at 7 o'clock p.m. on the 30th. That's a 19-hour gap. Plenty of time to get something to eat, to take a shower, to fill up with gas, get a good night's sleep, and drive all the way back to Mississippi. And again, Kirby was found at 12:30 on December 2nd of 2022. When did the Spences say they come back? They came back on the 3rd, and they stayed for the funeral on the 17th, and then they left on the 20th. 19 hours. The bank box. The first bank box that was opened by Jeff Spence was opened on December 2nd of 2022. Guess what? The same day Kirby's body was found. There's a safe deposit box lease opened by Jeff Spence, co-owner Terrence Spence. But what's significant is the box entry law. When does he enter that box? On the same day he opens it. At what time? 11:40. That's Eastern Standard Time, which is 10:40 Mississippi time. That's almost 2 hours before Kirby's body is discovered. If they didn't know he was dead, why they're opening up the bank box? And Mr. Hill made a big deal that, hey, you open up a bank box, nothing unusual about going into that bank box. But if you look at the Saltville branch documents, that box was opened up on December 12th of 2022, and the contents are in evidence. He doesn't enter that box until June of 2023. Why did he go into that box? On the day that he opened it, 2 hours before Kirby's body was discovered. Well, on December 4th of 2023, pursuant search warrants obtained by Virginia law enforcement, what do they find in the Chilhowie branch box? Number 11. This. And more importantly, more incriminating, not commercially valuable, is a check to David Barnes. Kirby M. Carpenter, 6071 County Road, 600 Boonville, Mississippi, $90. How'd that get there? Miscellaneous paperwork that Chris McAllister testified to. First is a simple envelope that you get from a bank when you withdraw money. Where's that from? People's Bank, Ripley, Mississippi. Bands are used to band money together. People's Bank, People's Bank. You gotta ask yourself, where's the money? It's in his pocket. And the receipts. Here's a receipt from Panthers Den in Dumas, Mississippi. Kirby's MasterCard. And here are some receipts that Chris McAllister testified that he verified that they were from Kirby Carpenter's account. Now, what do these documents do in that box? Because Jeff Spence grabbed Kirby's satchel and left. Testimony is that his satchel contains business papers, documents, and cash. All that's found in the Chilhowie box. The confession. Caitlin Spence testified that in December of 2022, he had gone back to Mississippi on the 30th and delivered a package that he implied were narcotics, pills. Placed him in the shed, I believe, underneath the bucket. So here he's confessing to going back to Mississippi on the 30th. And then we have the waterfall conversation that Caitlin testified happened between April and June of 2023. After she's reading all these social media posts, she's gone through counseling, and she just comes out flat out and asks Jeff Spence, did you kill Kirby? What did he say? No, I didn't kill him. What are you talking about? The less you know, the better. Don't look a gift horse in the mouth. Down south, we would say that as don't thump a free melon. If you say anything, you'll lose a NOLA and kill me. I did what I had to do. And Caitlin Spence testified that this was a confession. Now, Mr. Hill has made a lot of purported enemies that Kirby had throughout his life. Drug dealers in Memphis, business transactions gone wrong. Out of all the people, Caitlin could have said, "Hey, look, he was dealing drugs with Joe Blow in Memphis. He killed him." Who does she point her finger at? The guy that confessed to her father, his own daughter. The shotgun. Carolyn Aguayo, Caitlin's sister, Jeff Spence's other daughter, younger daughter. First grade teacher, wife, mother. Has no reason, nothing to gain from her testimony. She doesn't want to be anywhere around him. She doesn't want to know him to know where they live. She doesn't want him to know how many children she had. And he made the statement to her while watching TV that if you had to kill someone, he'd use a shotgun. Jeff knew it was easier to get away with using a shotgun because if you only fire one shot, the casing's not going to eject. Chris McAllister testified that it was a single shot from the shotgun. Now, significantly, again pursuant to a search warrant in December of 2023, Smith County law enforcement found a hidden, muddy, fully loaded shotgun under Jeff's bed. Pictures are in evidence. The shotgun was wrapped in a man's jacket. Muddy at the end of the barrel. Also important is the ammunition that was contained in the shotgun. He wrapped it 6 times, 6 shells ejected. I submit to you, the testimony was that the red shells are double off buckshot. Chris McAllister gave me his opinion at the coroner that Kirby was shot with buckshot. Jeff's phone. Caitlin testified that she tried to call Jeff on November 30th of 2022. She couldn't get it. And she asked him about this. And he said, "Oh, my battery was broken." All day? What was recovered in A1 storage was labeled a Faraday bag. You heard testimony what a Faraday bag is used for. Put your phone in there, nothing's coming in, nothing's going out. Easy way to hide your phone. Carolyn's testimony. What did she say about phones? She said that when Jeff had to cross state lines, he would give his phone to his wife so he couldn't be detected. You see a pattern here? Jeff's MO, modus operandi, how he gets things done. The shotgun. Kill with a shotgun, hidden underneath his bed. Why do you hide the shotgun underneath your bed? Wrapped in that jacket. Because you're trying to hide the murder weapon. Again, what the comment he made to Carol, if I was going to kill somebody, I'd kill him with a shotgun. The phone. Carolyn testified, yes, the phone was carried so they couldn't detect him going across state lines. His phone is, he's gone dark for the day of 11/30/42. The security cameras. Now you heard Carolyn testify that things had gone south with her parents. They had basically evicted him off their property. He came back to get his stuff out of the garage, and they watched him on the camera walk behind the shed, and then the cameras go blind. They go back to check it out, cameras been cut. Cool. Why did he do that? Crystal Coucher testified that Kirby Carpenter's security system, the cameras, had been disabled. Now, Mr. Hill said, oh, he didn't have access to the house. Yes, he did. Caitlin testified that she had told her parents where the spare key was located. So he didn't have to break into the house. There was no sign of forced entry because he didn't have to. He knew where the key was. He lived there for several months. The aggression. I wrote this down. During Carolyn's testimony, when they met at McDonald's to see if they could straighten things out, these are Carolyn's exact words. I saw an anger and a violence in his eyes that I had never seen before. I saw an anger and a violence in his eyes that I had never seen before. That's Carolyn's testimony. Someone has nothing to gain about beating him. Caitlin testified at the waterfall, her father had never talked to her like that. He was angry. JDC, Jeff doesn't care. A text from November 5th of 2021, about a year before Kirby's murder. Jeff says, you hire the talent. The older I get, the less life in prison is a deterrent. Jeff doesn't care. The older I get, the less life in prison is a deterrent. That's a text in response to Caitlin's question, tired of a job, hey, what other work can I do? And he says, Assassin's Inc. That full text chain is entered into evidence. Kirby's house. Again, Jeff knew about the spare key, knew where it was. Jeff disabled the cameras. Because if he doesn't disable the cameras, all this is for naught. Jeff shot Kirby, dragged and tried to hide his body. Picture of Kirby's house in January 600 in Chippewa County. Picture of the carport area. Looks like there's been some kind of scuffle. And I say that because behind that white garbage can were found Kirby's house keys. Mud on Kirby's pants from being drugged. And that's where he ended up. Underneath the curtain, secured by a toolbox from a pickup truck. Now, Jeff's alibi. The court has instructed you that's the state's burden, and we accept that burden, to prove that Jeff Spence was in Mississippi. And I just went through the litany of evidence that shows that he was in Mississippi. But listen, so we've got that burden, but let's look at the alibi. The alibi is based on one text, supposedly from Karen Spence to Caitlin. One text. About to cook hamburgers. Dad worked really hard today. The hounds are on the porch. That message. That brings the obvious question. Where was Karen? This is an unverified, unsworn, self-serving text message. Anybody can grab a phone, go into another room saying, hey, I'm having fun in Alaska. Why didn't Karen Spence come into this courtroom, be sworn in by the court reporter, sit down and testify under oath? I sent that text message. I was in Virginia when it was sent, and my husband, Jeff Spence, was with me. Where was she? I don't know where she was, but she wasn't here. Now, if you're accused of capital murder, and you're claiming you were somewhere else, and you see the number of just miscellaneous documents that are in all these bank boxes, it's almost like you hoarded receipts and things. Where are the receipts? Where's the receipt from the gas station where he filled up with gas in Saltville, Virginia on November 30th of 2022? Where's the receipt saying he bought a Coke and some naps?
Pardon me.
Why aren't there any receipts? Because he wasn't in Saltville. Why isn't there someone to come in here and testify and say, yeah, Jeff and I were together on 11/30/22 in Saltville. We sat on the porch, had a Coke, because he wasn't in Saltville. This alibi, this unsworn, unverified, self-serving text message is not an alibi. What they're claiming to be an alibi, thank you, but it's unsubstantiated. Why wasn't Karen here? Maybe she was tired of staying strong for the family, to continue covering up for Jeff. I don't know. All we know is she wasn't here. And you've got to ask yourself a question: how does a man with the financial troubles, with no continuing or employment whatsoever, how does he accumulate all this cash? If you look at the inventory sheets on the two bank boxes, he's got $62,000. That's just in the counted cash. That doesn't count the money that was wrapped in aluminum foil when he was arrested on November 30th of 2023, 1 year to the day Kirby died. I believe that was about $10,000. He claims that he deals in gold, silver, and valuable coins. Is there any dealer that came in here and said, yeah, I'll show you? And finally, the three people, his immediate family, who should be the most important people to him, his two daughters, both testified against him, and his wife didn't testify. That's got to say something. Confessed to Caitlin, Carolyn, again, a first grade teacher, wife, mother, credible, no reason to come in here and lie. They broke ties with, I think she called them Bonnie and Clyde. Scared of her. Don't want him to know where she lives. where her family is, how many kids she has. Jeff Spence had the motive, that's greed. Jeff Spence had the opportunity in 19 hours. Jeff Spence took this man away from Maddie Jane, his mother, his sisters, Casey and Wendy, and most importantly, his two children, Towns and Enola. Jeff doesn't care. Prison's not a deterrent to him. A deterrent to what? A deterrent to murder. He's guilty. Find him guilty. Thank you.
You let me know if you want a break. You could have to, Mr. Hill has up to an hour to have his closing arguments. I don't know if we'll use all of it or not, but if you'd like to have a break now before we start that, we'll give you one. You think you need one? Nobody says yes, I'm gonna say no. All right? You may make your closing argument for the state. For the defense.
If I don't speak loudly enough, let me know. Raise your hand. Just give me a sign. Let's review the timeline again because they're leaving a lot out. The Spence baby was born, the Carpenter baby, Enola, was born on July the 23rd, 2022. From that day forward, Jeff Spence and Karen Spence, either both of them or one of them, was in Tippah County, Mississippi, helping Caitlin learn how to be a new mother, taking care of the baby. I think Karen Spence was here almost the entire time, the entire 4 months. And Jeff would be here, go back, take care of their place in Virginia, come back, go back, and did that for that entire 4-month period. On November the 29th, that's a Tuesday, they both returned to Virginia. And that's a 10-hour drive. Unless you drive going a lot faster than you should. That's 10 hours. They left about 3 p.m. That's an evidence. 3 p.m. on Tuesday the 29th. Arrived in Virginia in the wee hours of the morning. I'll come back to the timeline shortly. Jeff opened the bank box on the 2nd of November, 2nd of December, I'm sorry. He opened another bank box on the 12th. The bank boxes that he opened on the 2nd and the 12th were visited repeatedly in 2023. The pictures that you see up here are items that were in these bank boxes a year later. They talk about the Chilhowie bank box. What you see, the pictures wasn't on December 2nd. It was in December of 2023, after search warrants were obtained a year later. Okay? The government claims a
told you when we started, the government claims things that they can't prove. They can't prove that Jeff Spence was in Mississippi on November the 30th, 2020. They can't prove that he was at Carpenter home. They can't prove that he did anything. There's no proof. No hard proof. There's nothing. No scientific evidence. Nobody saw him. He came all this way, did all this stuff, and nobody saw him. Now, on November the 30th, which is Wednesday, he was, in fact, with his wife at their home. And bear in mind now, they haven't been together in this home at that point for 4 months. She's been here in Mississippi. He's been coming and going. This is their first night, their first dinner as a couple in their own home in 4 months. Now, how do we know he's there? Well, 2 reasons. Number one, Karen and Caitlin have a text exchange. We all know what that is. We've got a cell phone. You write back and forth. I do it with my daughters at night. You know, just casual checking in sorts of emails. And this is qualitative evidence. You don't have to have it notarized. You know how I came into possession of this? Just so you know how this whole system works. This is not something I found, and I didn't find it, but it's not something I produced. This is the product of what's called discovery in a lawsuit, in a court case. Discovery, that means giving information. And you know where this information was obtained? By them. This came from them. This text message from between Caitlin and Karen came from the government. You know, when you get arrested, trust me, law enforcement types want your cell phone. They love your cell phone. They love to go through it and see what they can find. And that's what they did in this case. This is what they do in every case. They get your cell phone, they get a warrant to go into it, they go into it, and you've heard the word dump it, they dump it, extract it, dump it. And this produces information. It produces information. And the information that they produce, they didn't know I would find it. When I get the phone dump, it's thousands. It's not just, oh, look here. I have to go dig it for this. I guess they thought I wouldn't find it. Caitlin and her mother, I'll have this with you when you're back there. Caitlin and her mother are having this casual evening checking in sort of exchange of, what's for dinner? Sure did enjoy seeing Nola. She's such a doll, that sort of thing. And then Karen says, Dad and I are eating hamburgers in a few minutes. He just got up from a good nap. He worked hard today, inside and out. The hounds are back. I don't know what that's in reference to. Love you lots and lots. And then Caitlin writes back, LOL, good. I'm glad to hear that. I know you missed his hamburgers. Thank you so much, both of you, for helping out so much with the Noah. You are the best grandparents. I don't have to have that notarized. This is qualitative evidence that they discovered in a cell phone search, and it tells you that Karen and Jeff on November the 30th are about to have dinner for the first time together in 4 months. First time together in their own home in 4 months. Help you understand how to read these things. If you look at some of the small print on this text message right here, you will see that it was sent on November the 30th, 2022 at about 8 p.m. I hope you were paying attention when I had PayDae on the witness stand the other day. She didn't know I had found this. I don't have to tell her what I found. They had to give me the phone number, but I don't have to tell her what I found. I could bring it up in court, which is what I did. And when she was sitting right there, and I started quizzing her about this, she was paying attention. I hope you were. She was stunned. She didn't know what to say. And when I asked her, kind of difficult to kill Kirby Carpenter in Mississippi on November 30th, 7 or 8 p.m. and be in Saltville, Virginia, having a hamburger dinner at the same time. Isn't it, Jacob? Isn't it? Difficult. You remember, all she could say was, this is a quote. That's what it said. I could only retort to my question, how do you explain killing somebody in Mississippi and being in Saltville having dinner with your husband? Well, that's what it said. And that's what it said. She didn't need this waterfall confession. Waterfall confession never happened. This is, Kate Spence is up to her eyeballs in all this. I'm not sure you'll ever give up on the truth. And she knew she was up to her eyeballs. She was the first one investigating. She was the first one to lawyer up. And what she did in April of this year is get herself some relief. And you don't get relief from the government just because you want some relief from the government. You gotta give them something. And so she makes up this story about a waterfall confession, wanted to hear it from her father. And she knew on November the 30th, 2022, exactly where her father was, exactly where he was on November the 30th, 2022. Because on that day, she was communicating with her mother about hamburger dinner they're fixing to have. And then Caitlin says, I know you've missed his hamburgers. She knew where her father was on November the 30th, 2022. She didn't have to go ask him. It never happened. She's making it up. You know, what got Jeff Spence arrested initially was a statement from this guy named David Barnes. David Barnes was in trouble, just like King was in trouble. David Barnes was facing life imprisonment because he's a career criminal. And he went and gave a statement in 2023, a year after the time frame that we're talking about with Kirby. He went and gave a statement to Chris McAllister about something he heard at the funeral. Well, Caitlin, you heard her say, I asked her about that. Something that Caitlin said to him at Kirby's funeral. And Caitlin says, that's a lie. It never happened. David Barnes making it up. He's making up something that he can sell to the government to get him some relief. And it's got him some relief. He's not shipped off to prison yet. Interesting facts. That's what got Jeff Spence arrested. David Barnes' statement in November 23. Well, what David Barnes did in November 23, trying to get himself some relief from law enforcement, is exactly the same thing that Caitlin Spence did at the waterfall. She's making it, nothing happened at the waterfall. She's making it up. She's making it up to be as plausible as possible. She didn't have to go ask where her father was on that day, on that night, November 30th. She knew it was right there. She and her mother were talking about it. I hope you take note that David Barnes, who started this criminal case against Jeff Spence, was not brought into court. They didn't bring him. There's a reason. Because he's not credible. And another reason they didn't bring him is because they have two competing witnesses. One saying one thing, no, you're a liar. Okay? When we first met each other last week, I told you to make sure that you make the government prove its case beyond a reasonable doubt. Make sure you make them prove that Jeff Spence was in Mississippi on November the 30th at 7 p.m. beyond a reasonable doubt. Following the timeline further, they want you to believe, I told you, that they concocted this theory that Jeff, Mississippi and Virginia, came back to Mississippi, did the deed, went back to Virginia, with no proof. There's no proof of any of that. None, zero. Is that beyond a reasonable doubt? And to follow up their preposterous, foolish, almost theory, they create this almost impossible allegation that we left Mississippi in the afternoon of the 29th, drove all the way to Virginia, turned around the next day and drove all the way back to Mississippi, and then turned around and went all the way back to Virginia. Now look, they're saying that he drove 30 hours over the course of 36 hours. If he left Mississippi 3 p.m. on the 29th, drove 10 hours, he got to Virginia in the wee hours of the morning. He turned around and drove back to Mississippi. That's another 10 hours. It would be from 3 p.m. on the 29th to 3 p.m. on the 30th would be 24 hours. Right? That's a bet. 24 hours. Kirby is supposed to be killed at 7, that's 4 more hours. And then we turn around and drove back. That's another 10 hours or so. They're saying he drove 30 hours in 36 hours. 30 hours or 36 hours. That's over 2,000 hours. And what makes the theory of his conduct even less believable is that, you know, the evidence is that Kirby was very independent-minded sort. Live life on his terms. If you don't like what I'm doing, heck with it. You'll see me when you see me. I'm not coming home, I'm not coming home. And there is no expectation. Jeff is going from Mississippi, Virginia, back to Mississippi. And he is just coming back to Mississippi on the hunch that he might encounter this man. Oh, I'll just drive to Mississippi and see if I can run into it. Who in the world is going to do that? It makes no sense. It's foolish. So the notion that we did that is not plausible. It's not credible. The notion that we would even attempt a man that age, I mean, he's no spring chicken. And I see some younger folks in this jury box, y'all might be able to pull that off. But not many of us my age could. It's not far behind. No. We have several items to talk about. Please bear in mind that a search warrant was had on the Chill Howie bank box on December the 2nd, 2022. Mr. Mueller has shown you also photographs. That photographs are from December the 2nd, 2022. Those photographs are from a whole year later. They don't have any proof as to what was open in that box on December 2nd. You can just open the box. There wouldn't be anything to it. Certainly not what you saw on the screen. And then the next box was opened on December 12th, 22. And it didn't have anything until June of 23. Jill Howie box was visited 4 times in 23. Other stuff going in before the photographs were taken. The Saltville, yeah. The box opened on December the 12th. Didn't have anything until June of 23. And certainly nothing was put in it that looked anything like the photograph that you saw on the screen. These photographs, trust me, are not contemporaneous with this time. They are different. They are not contemporaneous at all. When we bring a witness in Carolyn who hasn't even seen these people in 7 to 8 years, hasn't even seen them, and they're going to use her testimony as some sort of convincing evidence. She hadn't been around Jeff Spence, Karen Spence, our sister Caitlin. She hadn't been around the entire family for a year. And she's so full of hate and vengeance, I'm pretty sure they don't care. You know, she lost me when she told y'all that her mother's illnesses were a matter of convenience. That when her mother needs an excuse, she's got help. Matter of convenience. If that's the least mistake you can show your mother, I think you don't want to talk to me. And I, then she's not going to do it. they haven't proven anything in this case. They haven't proved our presence, they haven't proved our any conduct at Kirby's house. They haven't proved that we knew how to get in the house. They haven't proven that we committed a robbery. What did we rob? They haven't proven any robbery. They haven't proven anything. They haven't proven that there was any attempt to go into Kirby's safes. No damage, no attempt, nothing broken, no locks picked. From the November the 30th supposed murder, I doubt it was a murder, but what Jeff said. I haven't figured out yet, and I've been sitting here for a week, I haven't figured out yet what exactly they claim was taken on November the 30th, the day that Kirby was murdered. What do they claim was taken? Do they honestly want you to believe that all of this stuff right here, all of this stuff that Kirby's killer killed him at 7 o'clock and loaded all this up before Caitlin got home at 8:15? That's what they say. I don't agree with that. That's what they say, using their timeline. All of this stuff? No, this is evidence of accumulated activity over the course of a long time. Remember, I had Mr. Johnson, a young investigator from Virginia, on the stand for a couple of hours, going through every item in that box, and that box, and that box, and that box. Every item. And every item in there, they showed some loose coins. There weren't any loose coins that I saw the other day. I asked him about loose coins. And he said, they're not loose coins. They are commercial products. Move it to see. You can look at it yourself. An individual silver piece, or silver dollar, or whatever. And it's packaged in a hard plastic container that could be bought. I always say royalty free because I have bought stuff there myself when I'm in Fort New Orleans. But you can buy it with us. You can buy it in Birmingham. Anywhere where there are products of this nature sold. And Mr. Johnson was asked, have you seen any evidence, Mr. Johnson, of when Jeff Spence came into possession of these items? No. Couldn't say. Could have had them for 40 years. Could have had them for a year, 2 years. Who knows? They don't have any proof. They're just, I told you the other day, they're just trying to squeeze whatever evidence they can and make it as punitive as possible against Jeff Spence. Trying to put, I use the analogy of trying to put a square peg into a round hole. They've been doing that for over 50 years. Right? And they're always going to catch it. They want to catch everything they do. It's a government tendency to make it as bad sounding, sinister sounding as possible for the accused. And the example that I'll use for you, if you look at they make out a return when they do evidence. They have a link. There's only exclusive links. And they accuse Jeff Spence of possessing, on the day that he was arrested, $8,200 counterfeit money. Well, that sounds pretty bad. $8,200 counterfeit money. He didn't have one red cent. He saw me have Mr. Johnson. Let's look in this bag. Let's open it up and see what's in here. Remember that? And we opened the bag with $8,200 in supposed counterfeit money. Well, it wasn't counterfeit money. It's play money. It says it, you look at it, it says it right on the document itself. Flip it over on the back side, it says, profit. Profit, that's profit, money, losers and stuff. Profit. It's a profit. That's simple about that bit. It's not counterfeit money. Okay, we wouldn't even try to pass it. What's left we'll take? It's not right. If Kirby supposedly, if Jeff supposedly brought pills that people say was wrong, why would they never find it? Didn't happen. Kate was just making stuff up to protect herself. Kate was making stuff up to shift the blame. Kate was making stuff up to earn her freedom. She's free. She is a free person with her daughter. They say I blame her. I might have done it myself, but that doesn't mean she gets to pass it off to somebody else, which is what she's trying to do. I think you need to bear in mind how much animosity Kirby had going on at the time, how much animosity he has generated over the course of his young life. How many people wanted to do it harm? How many people threatened to shoot him in the face? I just shoot him in the face. How many people wanted to drag him out to the street and beat him to death in the city of Richmond, where nothing would happen to him, is what he said. And when the people got mad at him over manipulating business deals, I mean, the people got mad and said that's the kind of money to kill over. All sorts of questions. Somebody killed Herbie Carpenter. Who was it? Have they proven to you beyond a reasonable doubt that it's Jeff Spence? No, they don't have any proof at all. Besides, I just showed you. On November the 30th, at the time he supposedly was in Mississippi to do this deed. He was at home in Virginia with his wife, and she is telling the daughter that. And the daughter knew it when she went to talk, or claimed she went to talk to her husband, or her father. And what year was it? 23 or 23? April of 23, June of 23. No, just didn't happen. The government wants to direct your attention to some other specific facts, like a shotgun found in a house in Virginia. What's so big about that? There's no connection. There's no evidence at all connecting that gun to Mississippi. None, zero. It's just another example of trying to make the evidence. Let's see if we can make it. many people own a shotgun. I own 5 of them. So nothing wrong with owning a shotgun. Nothing wrong with putting it wherever you're going to put it, back in whatever you're going to
How do we approach her?
I told you that you should pay particular attention to Caitlin Spence and her effort to get out of trouble and whatever she said about her father, and analyze these facts carefully as to her. Kirby was a drug dealer, and she was right there. Okay. Kirby sold methamphetamine, she was right there. Kirby sold pills, she was right there. Drug dealer, trust me. 50-year lawyer. There's a lot of violence associated with drug dealing. But she was right there with her. You know, going to Virginia, driving back to Virginia. That's a lot to believe when you got this woman right there in the house. You got this woman right there in the house. And not only do you have her right there in the house with you, but they had a history that wasn't always flowers. It wasn't always positive. She told you, and other people told you, Kirby was a difficult man. He had a temper. He had a tendency to violence. If you didn't agree with the way he wanted to live, Kirby was emotionally abusive to her. When I say emotionally abusive, I come on if I want to. If I don't want to, I'm not going to. If you say anything, I'm liable to give you a black eye. And he did. I don't believe Caitlin was happy in that relationship, and I think she's glad it's over. And one of the things that I found interesting that I didn't even know until this case was being heard. Chris McAllister was on the witness stand, and he wanted to play the 911 tape. And you heard after the dispatch answers the phone, answers the 911 call, then we have a very emotional, crying, upset young woman. And Chris suggested to you that was an act. And I suggest to you that it was an act. her to cover her own interest here. Remember what Chris said. A 911 call is recorded. It's recorded before it's answered. And when that 911 call was made, Caitlin wasn't crying before the phone was answered. She wasn't upset before the phone was answered. She was upset when she acted upset when the dispatch said, hello, or what's your emergency? That's when the crime started. In that space of time between making the call and it being answered, there was nothing. Caitlin was manipulating the situation. Caitlin was trying to deflect attention away from herself, just like she's done with this supposed waterfall story. It doesn't hold water in view of her discussions with her mother on the night of November 30th, 2022. Dad and I are fixing to have a hamburger at the same time that Kirby's supposedly being killed. Just doesn't wash. Doesn't hold water. You know, Chris McAllister is a long time Pepper County coroner and a long time Pepper County investigator. I've known him a long time. He shoots straight with me. And I think he shot straight in some arrows, but basically in this case. I don't recall anything from his investigation, what he did, that in any way connects Jeff Spence to here, to this case, to this murder on November 30th, 2022. Chris did all this investigation, and I can't think of a single fact that he could testify to that points the finger at us. There's no connection between cameras. There's no connection. There's no proof of any connection between surveillance cameras. There's no proof of any connection concerning any sync module. There's no proof of any connection between any attempts to steal money from inside safes. There's no proof of any connection between any supposed hard evidence, scientific evidence, forensic evidence. All we've got here is theory and everything they can do to make whatever they find fit that theory. Of course, Chris did make some mistakes. I mean, there are no fingerprints. No fingerprints off of Kirby's door to his truck. If somebody's going into that truck, you know, it self-locks. Anybody going into that truck, they have to open the door. You would normally see in a criminal case, connecting Jeff Spence to this place at that time. That day, that nothing. Caitlin, on the other hand, had a lot to protect. She claims that she find it interesting. See if you can help me out here. Kirby is supposedly killed around 7 p.m. on Wednesday, November the 30th. And somebody does what they do to him. That's not the sort of conduct that you would expect of somebody who would be in a hurry if he has driven all the way from Mississippi to Virginia back to Mississippi, and he's going to kill him. He's going to steal all this stuff, and he's going to go to the trouble to get him around by the metal coverall, put him underneath the toolbox. That's not somebody who has driven 2,000 miles, has driven all these hours in a very short period of time. That's somebody more local, somebody who's got time, somebody like Caitlin Spence and whoever she might have a friend to help her. She's not in any hurry because she's living there at the time. She's not living, she's not in a hurry to leave. Whoever kills Kirby at 7 o'clock, 7:15, going to steal all this stuff, steal stuff out of the supposed satchel that we've never seen. He's not going to be hanging around. If they were, wouldn't she see him when she gets there a little after 8 from Boone? Yes, of course she would. So the simple facts of how this supposedly was happening does not support Jeff Spence. It more likely supports Caitlin Spence and whoever she had as friends. She's called some of the names of her friends. I'm not going to call them again. But y'all heard. She's protecting herself and somebody else. And she's sacrificing her problems in the process. There he is. Well, I'm not letting him go. I'm going to waste time. Kirby Carpenter had a habit or practice, I'm not sure it's a habit, a practice of he owes me money, so he writes me a check. And I say, can you cash this? Because I give him the check back, and he cashes it for me. I put the cash in my pocket, and I don't like it. That check handed back to him that he had written becomes a receipt. It's like a receipt. And that check to David Barnes was dated April the 21st, 2022. It's here somewhere. You'll see it. All that check proves is this, that at some point after April the 21st, 2022, at some point, Kirby and Jeff did business. And Jeff was there a lot. After August, he was there almost all the time. They did business together. And they had done business before then. But after that check, and why it comes into Jeff's possession, is because inadvertently it was put into a bag or a box where Kirby was delivering stuff to Jeff that Jeff had bought. Some of the stuff that you see over here. That's all. Had done business together. You know, we've heard from Caitlin, we heard from Chris Johnson that the inside of Kirby's house was basically a mess. It was full of papers and clutter. And the fact that we end up with papers and clutter in some of Jeff's possessions in the bank houses. It's nothing more than inadvertent grabbing something and sticking it because of all. That's all it means. Doesn't mean anything else. The, there is no connection between anything that the government claims that we did that they have proven beyond a reasonable doubt. All right. I remember that there were plenty of people who wanted to do Kirby. Ray Palmer, David Hancock. Remember the guy who, Adam Gates, chased him down in Boone, assaulted him in a parking lot with a gun. Memphis, biker gang, Nashville, diamond guy, all had reason to want Kirby gone. And drug dealing in and of itself is enough to raise your eyebrows. You know, the government they tried to lend credibility to Caitlin's supposed waterfall confession that she calls it. And I just don't. I have a two-layered response to that supposed waterfall happening. The first layer is it never happened because she knew where he was. The second layer is assuming that it did happen. What she said is not nearly as telling as they want it to sound like. It didn't happen. But, you know, I have two daughters, and I can imagine if either one of my daughters was living life with Caitlin's reality, I could end up saying something very similar to it myself. If I had a daughter who was living with a drug dealer, involved in drug dealing, if I had a daughter who was living with a man who had people engaging in high-speed chases, Adam Gates, for example, chasing my significant other down, assaulting him with a gun. I had a daughter who was living with a man who was emotionally abusive, wasn't committed to a relationship, show up when he gets good and ready. If I had a daughter who was married to a man, or living with a man who had propensity to smack you if you had anything to say, leave marks on you, black eyes, bruises. If I had a daughter who was living that reality, I could very well see myself saying, look, honey, you got your daughter. You got a lot to live for. You're out of a bad situation. You're no longer living with people who are doing what this guy was doing to you. what he was doing to make a living, what he was doing to make money, the exposure, the high-risk conduct. Don't look at get towards the mouth. Move on with your life. I can hear myself saying that. Sure as heck. And I think a father that would say that to a daughter would be a good father. It doesn't mean what Kate mean, but it never happened because Caitlin knew exactly where her father was on November the 30th, 2020. He was at home with mom. First time they've had together a dinner in their own home in 4 months. Spent the day working, took a nap, cooking hamburgers. You see it. You'll see it right here. This is digital proof. Your cell phone, you know, that little guy follows you around. And he's recording evidence when you don't think it's recording. It follows you around, recording evidence. And to the extent that Caitlin says, or they want to make out like Caitlin says she can't get in touch with her father on November 30th. Batteries broken, whatever. This little guy is not to be denied. And I don't, if that were in fact the case, let me tell you what happens. Let's assume that my battery's broken. And you can't call me because my phone's not working. It's not answering. Or let's assume that, like I do every Friday night, I turn the dead damn thing on. It's off. Well, it's off only to an extent. Because if this little guy is not really ever you're calling me and my battery's broken, and you leave me a message, and you call me again, and you leave me a message. Those messages don't go into outer space. When this phone is powered back up with a battery, or I turn it back on, you know what happens to those messages? You got a hunter. They come flooding in. They come flooding in. They're not gone. They come flooding in. And if Kate called her dad on November 30th, now we should believe there's something sinister's going on because I couldn't get in touch with him. If you left a message, it comes through. When the phone is batteried up or turned back on. And we don't have any such evidence because it didn't happen. She's just trying to bolster her claim. They're trying to bolster their evidence. They're trying to make stuff go. That's all? Thank you. Exhibit 50. Exhibit 50. This is proof. In Mississippi, on November 30th, 2022, at 8 p.m. And this is nothing more than foolishness, playfulness, foolishness between a parent and a daughter. That's all it is. There is no assassin, never will be. There is no business that they're in together. This is just foolishness. And don't be misled by that. You've got all the returns, the entry log, one bank box, another bank box. Just bear in mind that those boxes were visited. This one's 2, 4, 6, 8, 9, 10 times in 1 year. This one's 4, and another one's 7. And what they're showing you from these pictures, well, after all of these visits, the stuff that's being put in. Those pictures aren't contemporaneous with Kirby's death. The pictures are a year later, over a year later. Search for this stuff. Don't be missing it. Sit down and talk, start talking about this case. Remind each other. When you leave here, you should feel good about the decision. If you don't know who Kirby's killer is, and we don't, and if you're not sure, then your vote's not guilty. Because I don't have to prove anything, even though I have to. I don't have to. He doesn't have to. That's not the way the game is played. That's not the way the system works. The government claims they have to prove everything to make them guilty. Thank you, sir. I'm done.
All right. Ladies and gentlemen, the jury, let's just take a little break. Go down out there a good while, make it pretty quick, and the state be ready for it to close anyway. All right, court being recessed until about 15 minutes, 10 to 15 minutes. Nailed it down there, didn't you? All right, everybody good on the jury? You may make your final close for the state.
Thank you, Your Honor. At the break, I was talking to Carson Moore back there. He's a ADA with our office. We were talking about, how many times have we tried a case where alibi was claimed as a defense and never heard from the alibi? And in all my years, since the year 2000, in all of his years, zero. Where's Karen? Where is she? And that's really important too, because I've heard David Hill up here, and there are some things I agree with about Chris McAllister. I don't know where he is. He should be in here. Anyway, Chris McAllister is a good investigator. And what he did is investigate this case. And he followed the leads, and everything that you have before you is because of his hard work. And he, according to David Hill, he's a straight up guy. And that's what he did. He followed the leads, and that's why you have this evidence here. And we'll get into that. The first thing that I want to disagree with David Hill about is when they want to drag Kirby Carpenter through the mud even greater today, and in this case, than they did when they dragged his dead body and put a curtain over it and then placed a toolbox on it. They drug him through the mud. Guess what? When Enola was born, Jeff Spence and Karen Spence were there for 4 months. In October, you heard testimony that they all went up to Pennsylvania to meet the family up there. Does that sound like a drug dealer, that they would want him to go and meet the family up there? Does that sound like somebody that was abusive